A lot of times in litigation situations, the litigator might say, well, the defendant looks like he has a lot of assets, so let's proceed forward, versus, well, the client doesn't have much in the way of assets, so we can only take this so far. So it really has an effect on whether the litigator is going to bring the action or not. And as part of that, we're in a contingency fee system, so oftentimes this results in potentially frivolous lawsuits, and suits may be brought more for nuisance value, and this happens a lot, where somebody might bring a claim and expect that the defendant will settle before going to court just so that they don't have the expense of going to court. Also, there's the concept that once you've been sued, you've already lost. This is more of a psychological type of impact on defendants in suits where they may feel that they're carrying the whole weight of the world on their back. And plaintiff's attorneys know this. It's a major life event to be sued oftentimes. And, as an example, somebody may be sued and after 5 years ultimately win the battle, but they've paid hundreds of thousands of dollars, their business has suffered, their marriage has suffered, and they won. So we think it's better to take steps sooner than later that discourage these types of suits, or at least lead to early and inexpensive settlements. Because another thing in the litigation system is, in the U.S., we're sort of unique in that each side generally pays their own way in litigation, whereas in other places around the world, the loser pays the attorney's fees for both the loser and the winner, at least to some extent. So this is another thing that weighs on defendants. Next slide. Goals of asset protection planning. Well, it's important to use a user-friendly type of plan. Don't use anything that is going to be too complex. You want to deter litigation, you want to reach a favorable settlement, put yourself in an improved bargaining position, but you want to use a user-friendly plan. Remember that clients are laypersons. Don't use something that just uses a myriad of entities, that is really designed to confuse third parties or to hide assets. That will just frustrate the client too. It should be properly designed so that it's based on sound legal theories. And I'm jumping to page 8 here, where it talks about deterring litigation. As we said, you want to see if you can avoid the deep pocket syndrome. Remember that wealth itself is a target. Even liability insurance can be a target. If you have a really great liability insurance policy and the plaintiff knows that, it can be, in a sense, a magnet itself for litigation. So what you're looking for is early and cheap settlement, knowing that the economics drives the legal system. Litigators know that it's one thing to win a case, it's another thing to collect. So what you're trying to do is level the playing field. If a client doesn't have asset protection planning in place, there's little they can do as a defendant. Whereas if they do have asset protection planning in place, and this is the important point, it really sort of creates hurdles for the plaintiff, and it levels the playing field in litigation. It improves your bargaining position, and sometimes you can even play a little bit hardball if you are in a position where your assets are well protected because of the hurdles that the plaintiff would face in trying to get to those assets. But you should also be trying to, in a sense, win the game. Not just hurdles, but design it so that ultimately, if push comes to shove, it will be protective. It's not just sort of one step ahead of the creditor. It's not moving assets around. It's not using trust with flight clauses or hopscotching from one jurisdiction to another. Those can't be relied upon to win in the ultimate battle. It's also good for clients to know that sometimes a client will walk in, they'll be thinking of certain risks that they have, like a doctor may have certain risks, or a real estate developer, or somebody in the securities business. But they should also know that potential liability can come from any source. It can come from a sideline business that they might be involved in, or if they own a rental, there might be a slip and fall. So there are a lot of good reasons for the asset protection planning.